daily list, item number 1.
Yes.
Well, this matter has come up before your lordship on reference.
Yes.
Lord, here, Lord,
Yes, tell me.
when this matter was earlier,
Yes, Mr. Thapar, please continue.
Lord, I'm praying for some time in this matter. My Lord, we'll have to perhaps file our reply. Because on the earlier round of litigation, my Lord, when this matter was pending before the single bench, we had filed our objection raising the preliminary maintainability of the...
You will hear on the issue of maintainability.
Whether your lordship will rely on the same petition which you had filed earlier, or your lordship will grant us time to file a fresh one.
Milord, may I submit, Milord?
Yes, Mr. Kumar.
Milord, kindly see there is a direction which is issued by the arbitral tribunal, Milord, whereby the direction is to comply with the interim order. That interim order has not been complied. Since interim order has not been complied, under 29th contempt petition is maintainable, Milord. I have relied and referred to 2 judgments of this court, of the High Court and even Supreme Court, Milord, of Justice Nariman judgment, Milord. Now they have filed initially reply only with regard to maintainability, Milord. They have not filed reply, Milord. Contempt is made out. They are not paying the lease rental, Milord.
Mr. Kumar, Mr. Kumar, we are still at the stage of looking to the matter whether it's maintainable or not. To that extent, since they have raised the issue of maintainability, we'll decide the issue of maintainability. If at all it is maintainable or not.
What I was saying, Milord, what my submission is that your lordship decide both the issues, because it is like giving them long handle.
Yes.
Because they will first raise the issue of maintainability, they will not comply with the order which was passed in December of last year, Milord. How long they can evade the order of the...
Yeah, if you're ready.
They have been... Again, I'm saying your lordship may decide the matter.
Yes, Mr. Kumar. We'll hear them.
I'm praying for some time today, my lord. Senior counsel is not well. Lord, he's not in a position to appear personally before your lordship due to some personal difficulty. We can have this matter next week, my lord, subject to your lordship's kind convenience.
We'll have it on
Tuesday. Let it be on Tuesday, my lord.
Mr. Thapar, learned counsel for the respondent has sought for accommodation on the ground that the learned senior counsel, Mr. K. Paul, who is conducting the matter, is indisposed. Accordingly, on preamid, the same is allowed. As agreed to by the parties, list this matter on 6.
Highly obliged.
Grateful.
How to raise bill in such a like never taught in the college. Never taught the new what is
May it please, Lordship. Lordship, I beg to make a mention in item 5, Your Lordship. Item 5 and 6 is connected matter, Your Lordship.
I think last time we have made it clear that this matter is to be heard definitely today.
Lordship, I tender my sincerest apology, Your Lordship.
But you were requested to prepare the matter.
Lordship, it was my colleague, Your Lordship. Lordship, I tender my sincerest apology, Your Lordship.
2019 matter. My apology, Your Lordship. On pre-meet by the petitioner, matter is adjourned. This is the of the 3 weeks.
Lordship, similar prayer for item 6 and 8, Your Lordship.
Yeah, 5. That's 5 and 6.
Lordship, 6 and 8. Lordship, similar prayer for item 6 and 8, Your Lordship.
5 and 6 are similar. I mean, related matters, isn't it?
Yes, Lordship.
Order has been passed. Now 8.
6, 7 and 8, Your Lordship. 7 and 8. 5 and 6, earlier.
On pre-meet by the petitioner, seeking adjournment on grounds of personal difficulty of the learned senior counsel who is conducting the matter. Matter is adjourned. This is the same after 3 weeks.
Highly obliged, Your Lordship.
May it please your Lordship. Lordship, I beg to mention item number 10. This matter may kindly be taken up next week, my lord.
What is the ground?
Conducting counsel Mr. SN has some personal difficulty, my lord.
But I thought I saw Mr. Sen earlier.
He's there in the court, but he has some personal difficulty. He has asked me to take time for till the next week.
On pre-meet by the petitioner, seeking accommodation on ground of personal difficulty of the learned conducting counsel, Mr. S.N. Matter is adjourned. This is after 2 weeks.
I'll do it.
Please, Your Lordship, I beg to mention item number 11.
Why?
Your Lordship, we need more time to prepare.
Learned counsel for the appellant has sought for accommodation in this matter on the ground that he is not prepared to be heard today. On the same not being objected to by respondent, matter is adjourned. This is after 3 weeks.
May I please, Lordship, I beg to mention item number 12, Your Lordship. Your Lordship, in this matter, I humbly pray 1 week's time, Your Lordship, because we have to receive the original record and some clarification regarding the payments, Your Lordship, of the staff. How much they have, like, they're supposed
Yes,
to get.
you're just to supply that chart.
Yes, Lordship, we haven't received, Your Lordship. I humbly pray 1 week's time, Your Lordship.
On pre-meet by the petitioner, this is matter after 2 weeks.
On daily list, item number 1.
Lordship, in this matter, the union and the respondent number 2 are supposed to file their counter.
Yes, where's Mr. Devnath?
Rakhal Devnath, I think so.
I mean, the last order would reflect that there is a confusion as to who would swear the affidavit on behalf of the union. Whether it would be the CEO of the Cantonment Board, who is already a party.
But today morning he said he will ask some time, I think. He told me that. But anyhow, he's not
He
here.
was here and earlier in the division bench, I think he was there. Have you filed yours?
They have filed this.
You have filed before the court. Before the court. Stop. It may be pointed out that in the previous order of this court, dated 15/7/2024, the Leonard CGC has made a submission before this court to clarify as to whether the counter affidavit on behalf of the respondent 1 and 2 is to be sworn in by the CEO, Chief Executive Officer of the Cantonment Board or not.
No, Chief Executive Officer, I'm for that, but he'll be for the DO.
For?
DO, Defense State Officer. Because it is the same person.
Have you read the previous order? Previous order says this. Since a communication has been received indicating that the Chief Executive Officer of the Cantonment Board is the competent authority to swear the affidavit. So this is with regard to respondent 1 and 2. As far as 3 and 4, yes.
CEO has filed.
CEO has filed. Right. So whether it is the CEO would be competent to file the affidavit for all respondents. That is the issue that remains. It would be, logical to assume that, but
ultimately, I think it will be the same affidavit probably.
But since they have been arrayed, separately.
I do.
So, Mr. Deputy, what happened to you? Matter was called up, you are not here.
I was in executive.
You have already been marked absent. Do you like it when you go to work or you go to school when there's red mark against your name?
Yes.
Tell me, what is your instruction?
My instruction, last question I have shown that to discuss with this.
Yes, so have you?
So this after this I was discussing the matters with the CEO here, and already he has filed the affidavit. So
he has filed the affidavit on behalf of respondent 3 and 4. We are talking about respondent 1 and 2.
Yes. So
if you are not willing to file or not required to file the affidavit on behalf of 1 and 2, matter will proceed. It comes to the same thing. If you are fighting for the same cause, it comes to the same thing.
Only this much was required, whether any materials is there, which is this to be filed by the Union of India, and it is to be included only
So
this much.
that would be your stand. Now, who is the competent authority to file that? It's up to you. In fact, this court has indulged to the extent that some time was given to you to sort out the matter. You have not done so.
Maybe 1 week you will see.
Mr. Arya, cross-note to Mr. Adamnat, the CEC, appearing for the respondent 1 and 2 of the Union of India, has submitted that he has not yet received any specific instruction as regard as to whether the Chief Executive Officer of the Cantonment Board is the competent authority to swear the affidavit on behalf of such respondents. Accordingly, some more time is prayed till specific instruction is received. On pre-made, seems along, this is matter after 1 week.
Item number 3.
Please, Lordship. Lordship, in this appeal, notice has been served on respondent number 1 as per the advice from the website of the Postal Department. But looks like unfortunately no one is yet appearing for respondent number 1, so we'll file an affidavit of service, my lord.
That is for what?
Number 1, respondent number 1.
2 and 3?
2 and 3, my lord, notice has come back, I believe. 2 and 3 answered. 2 and 3 are the owner and the driver. So as far as 2 and 3, my lord, the approach that my lord had adopted in earlier cases, that since it had already gone ex parte in the trial court in the MST, and appeal being the continuation of the trial proceedings, there is really no need to, number 1, implead them, or even if impleaded, to serve notice on them. If I can draw Lordship's attention to the earlier order passed in another matter by my lord.
True, but would that be the correct law?
It is the correct law, for the reason that if Lordship kindly looks at this order, the second paragraph, learned counsel for the appellant has further submitted that since considerable efforts have been made to cause notice to be served upon the said respondents, but with no positive result, and considering the fact that this is an appeal which is a continuation of the proceedings of the suit, or rather the claim referred before the MACT, therefore it is prayed that the respondent number 2, 3, 4 and 5 may be proceeded ex parte in these proceedings. On consideration of the prayer made, subject to the appearance of the respondent 2, 3, 4, 5 at any point of time, for the time being, the matter shall proceed ex parte. So it's only an order passed for the time being, as and when and if driver and owner appear, which they never will, because in this case also it had gone ex parte many years back.
Whether I mean, is the insurance company appearing for them? Under
170.
175.
If there is a failure to contest from their side, we take over the defense, my lord.
Exactly. So have that been done before the claims tribunal?
Lordship, actually, that 170 law has slightly changed from 2014 onwards. Supreme Court clarified that if the insurance company is made up, number 1, insurance company is not required to be made a party in MST proceedings. Only notices and information notices is required to be submitted, is required to be given to them. Number 2, if they are made a party, if they are impleaded as a formal party in
that information would be under 156, 158.
158, my lord, 158. Number 2, my lord, if they are made a formal party in the claim petition, then they have a right to take up all and every defense that would otherwise be available to the owner, my lord. So 170, after 2014's clarification, I'm not required to really file a petition and get a formal order on 170. The very fact that I've been made a party in the proceeding means that I can take up any and all defenses that would otherwise not be available to me, would be available only to the owner, my lord. This was from 2014, United India versus Sheila Dutt, my lord. 2014.
I don't have the citation to me.
I'll supply the citation. It's 2014, AIR 2014, page 1. It's page 1, so I remember it. Okay. I'll give it, my lord. I'll give it.
So what is the situation here?
So situation here, my lord, is if Lordship looks at the impugned order, that will show, my lord, that is at page 1 minute. Page 41, my lord. Page 41, para 5 of the impugned order. Steps were taken to both previous owner and new owner of the vehicle on so and so and so and so, wide so and so and so and so, but there was no service report nor did the notices return unserved, and by order dated 7/3/2019, the service was deemed complete and the case proceeded ex parte against them. So, impugn order, my lord, itself reflects that in the trial, in the lower forum itself, matters gone ex parte against.
Where is the observation that their stand or their stand was taken up by the insurance company?
There is no specific observation, but through operation of law, my lord, insurance company has taken up the complete defense, my lord. And
Okay, so that is as far as respondent 2 and 3 are concerned.
2 and 3.
Now come again. As far as respondent 1 is concerned,
I'll file an affidavit of service, my lord, within a week's time.
notice has been effected.
It has been effected as per the website, the Postal Department website.
You see, as far as issuance of notice is
Yes, ma'am.
affected by post office,
Yes, ma'am.
see, the post office or the employees of the post office would not know the law as regards summons.
True, ma'am.
They would just go dump the item, material, whatever, in a post box or in front of the door or whatever. If somebody comes, the maid servant comes and receive it, fine.
Lordship, that would be for a normal post, but these are registered ED letters, my lord. So unless somebody receives it and it is noted who has received.
Who is that somebody? Because you know very well.
Yes, my lord. Usually, my lord, what happens is in the website, at least nowadays, they reflect received by so and so.
No.
These
What
reports.
what is usually reflected is item delivered.
True, my lord. Item delivered. For example, in this case, my lord, the item was delivered. Item delivered, addressee. That means to whom it was addressed has received it. So, based on this, we can file an affidavit of service as far as number 1 is concerned. Number 1 should have appeared. Number 1 is the claimant entitled to the money. But that's claimant's choice, my lord.
So the award has not yet been disbursed.
No, it remains unpaid, and claimant has not come forward for the last 2 years to enforce it also.
You have deposited at 25%.
Yes, my lord. Before this
25,000 or 25%?
25,000. That we have deposited.
Mr. S. General, Learned Counsel for the petitioner, applicant or petitioner. This is for condonation of delay.
Yes, my lord.
Petitioner has submitted that the notice issued upon the respondent number 1 has been duly affected. However, it is prayed that an affidavit of service may be allowed to be filed to incorporate the acknowledgement as far as respondent 2 and 3 are concerned. The Learned Counsel would submit that the office note would reflect that the notices have returned unserved. In this regard, it is prayed that this court, as has been observed in an earlier case, in similar circumstances, that is in MC and MSC app number 1, wherein by order dated 21/4/2022, in the case of New India children, this court on the service of on the notice issued upon the relevant respondent, that is the here it's I think 2, 3, 4 and 5, not only the driver and the owner, could be on all the
Lordship,
the order that you had referred to.
yes, but in that case, my lord, there were two vehicles, so there were two owners, two drivers.
Kunum Doko. The owner and the driver therein having not having been served upon such respondent, and noticing the fact that in the proceedings before the tribunal, the said respondents, that is the owner and driver, have also remained absent, which an ex parte order was passed to proceed against them, had in a similar vein come to the opinion that even in an appeal proceeding, in the event the said respondents are found to be unresponsive to the notice issued upon them, matter could proceed ex parte. However, with a rider that the said respondent could join proceedings at any point of time. On this premise, this court would also agree with the learned counsel for the petitioner that as far as the respondents number 2 and 3 herein are concerned, when have you issued notice upon them?
Lordship, can you give me a moment?
Only in June. This matter is in June now.
On 2nd July, my lord.
July. I think you should take it
1 more week's time, my lord.
Just for abundant precaution.
Just that 1 month period.
Then we'll cancel the whole order. Just simply say that you have to take 5 steps.
As long as Lordship passes the same order on the next date.
I don't need to.
She can preserve it. Steno can preserve it.
This is an age of copy paste, so we have to. True. As far as respondent 2 and 3 are concerned, Mr. Jindal has submitted that since the office note would reflect that the notice has returned unserved, it is prayed that another opportunity may be allowed for fresh notices to be issued upon them. Pray aloud. This is matter of 2 weeks.
Obliged.
Item number 4.
Lordship, in terms of your Lordship's last order, Lordship, we are supposed to file affidavit of service, Lordship. Lordship, we have made a request to the Postal Department for giving us the delivery report, Lordship, in respect of the 3 respondents, Lordship, 2, 3 and 4. That is still awaited, Lordship. So I am praying, Lordship, 1 week's time to file the affidavit of service, Lordship.
Mr. Learned Counsel for the petitioner has submitted that the notice issued upon the respondent number 3 and 4 has been duly effective. However, some time is prayed for an affidavit of service to be filed in this regard, since the necessary papers have not yet been received from the post office. On premier, it seems allowed. This is matter after
Lordship, interim order may be extended, Lordship, till the next date, Lordship. I'm praying.
In the meantime, the interim order passed earlier will remain in force until the next date fix.
Lordship. Hello, Lordship.
Item number 9.
Lordship.
Yes, please. You ready for the hearing?
Lordship, I'm ready for the hearing. There are 2 points that I have taken up, my lord. But, my lord, only on one point I will be able to speak. The second point, my lord, we could not prepare. So, take it next week. Lordship, otherwise let's take up permission next week. I'll just prepare the second point. We'll finish.
On premier by petitioner, this is matter of 2 weeks.
Obliged.
Second call, item number 1.
Yeah.